Welcome to Deep Dive. Today, we're really digging into a critical administrative change in U.S. policy. It's something that hasn't gotten maybe the biggest headlines, but it could fundamentally redefine how American citizenship is verified.
Yeah, the main thing we need to unpack is this. For a very long time, a U.S. birth certificate was, well, pretty much all you needed. That might be changing. It might soon not be enough on its own to prove citizenship for things like getting a social security number, an SSN. And this isn't just about paperwork, especially for the millions here on temporary visas. It could seriously impact family planning.
Exactly. And our goal today really is to bring some clarity here. We need to look beyond just the surface, understand the background, the specific new rules federal agencies are actually preparing for right now, and what this really means for lawful residents and temporary visa holders. It's quite significant.
Okay, so let's start with the basics, how things have always worked, more or less. For over a century, the foundation has been the 14th Amendment. Citizenship for almost anyone born on U.S. soil. That's just soul eyes, right? The right of the soil. That's right. And historically, that was basically the end of the story. You showed up with a birth certificate, born in Ohio, say, and the Social Security Administration, State Department, whoever, they accepted it. Done deal. Proof for your SSN, your passport. It was simple, efficient, reflected that core constitutional idea.
But that's what's being challenged now, not through a new law passed by Congress, but through administrative action.
Precisely. There's an executive order, first floated a while back, that agencies are now gearing up to implement. And that's the big shift administratively. It tries to put new conditions on how we verify that birthright citizenship.
Okay, so break down the core change for us. It sounds like we're moving from just asking where someone was born to asking about their parents, who they were, and what their status was when the child was born.
That's exactly it. The Social Security Administration, the SSA, is getting ready to rewrite its internal procedures, its manuals. Those manuals used to say, birth certificate, good enough. Now, the plan is applicants will have to show proof that at least one parent was either a U.S. citizen or a lawful permanent resident.
That's green card holder?
Right, a green card holder. At the time of the birth, the birth certificate itself, the location, isn't enough standalone proof anymore.
Okay, let's get into the weeds a bit then. If the birth certificate isn't the golden ticket anymore, what will people need? What documents are we talking about? This sounds like it could be a huge headache for immigrant families.
Oh, it absolutely raises the bar significantly. You're potentially talking about proving legal status from years, maybe decades ago. The SSA is basically setting up different tiers of required documents based on the parent's status at the time.
All right, scenario one. Parents were U.S. citizens. What's the requirement then?
Well, for children born before this order really kicks in, maybe old SSN records showing the parents were citizens or their place of birth might work. But for kids born after this rule change, the requirements jump way up. They'll want original documents proving a parent's citizenship. Things like a naturalization certificate, a U.S. passport, maybe a consular report of birth abroad, or an official citizenship card. The key is proving that status verifiably.
Okay, and what about the large group of people here legally, but not citizens? Green card holders, refugees, people with asylum status. Many professionals fall into this category.
Right. So if the parents were lawful permanent residents, LPRs, when the child was born, the SSA will want the official proof of that status. Usually that means the physical green card, the form I-551, or maybe documentation showing the valid immigrant visa that led to the green card. And critically, those documents have to show the LPR status was active, was current when the child was actually born.
Timing is everything then.
Absolutely. And similarly, for children born to parents who were recognized refugees or heir asylees at the time, they'll need the Department of Homeland Security paperwork. That could be an I-94 arrival record or other specific documents confirming that protected status was valid right at the moment of birth. The big takeaway for you listening is, yeah, we've shifted from just checking the place of birth to potentially a deep dive into the parent's entire immigration history. That list of documents is a lot. But here's something interesting. The order isn't actually fully in effect, is it? Because courts have stepped in.
That's right.
So you've got these nationwide injunctions from, I think, the First and Ninth Circuit courts, basically telling the government to pause implementation. So why are agencies like SSA and states still preparing as if it is going to happen? Isn't that jumping the gun? It's a really interesting point about how government agencies operate. You could see it as administrative strategy. The courts, by issuing injunctions, have definitely put up a red flag, suggesting there are serious legal questions about whether the executive order oversteps its bounds, maybe clashes with the 14th Amendment. But, and this is key, Injunctions are usually temporary. They aren't the final legal decision. So agencies are getting everything ready behind the scenes. They're updating their internal manuals, figuring out the new documentation processes, training staff.
So they can flip the switch immediately if the courts allow it later.
Exactly. If those injunctions get lifted or maybe overturned by a higher court, they want to be ready to implement the new system right away without months of administrative delay. It's about being prepared for that potential green light.
Okay, so the bureaucratic wheels are turning, waiting for the legal outcome. Now, the clear aim of this policy seems to be limiting automatic citizenship for kids born to non-citizen parents, maybe particularly undocumented parents. But critics have raised some pretty serious alarms, haven't they, about unintended consequences?
They absolutely have.
Yeah.
A major concern voiced by critics is that this policy, if it goes fully into effect, could inadvertently create a category of stateless children.
Stateless? How does that happen?
Well, it goes back to those two concepts, jus solis and jus sanguinis. Jus soli is the U.S. model citizenship based on birth location, right of the soil. Jus sanguinis is right of blood citizenship based on parents' nationality, common in many other countries. So imagine a child is born in the U.S., but under this new rule, they don't qualify for U.S. citizenship because of their parents' status. Then, if the parent's home country also doesn't grant citizenship automatically just because the parents are citizens, maybe it has complex rules or doesn't allow citizenship for children born abroad easily under jus sanguinis rules, that child might end up with no citizenship anywhere.
Legally belonging nowhere.
Exactly. Which creates enormous problems, human rights issues, legal limbo. It's a serious potential consequence that critics highlight.
Okay, shifting focus slightly. Let's talk about the direct impact this could have, or is already having in terms of planning, for people here on temporary visas, students, professionals.
Yes, this is where it gets very real very quickly for a lot of people. Think about the huge number of international students on F1 visas, or professionals on H-1B or L-1 visas. For years, the assumption has been pretty solid. Have a child while you're in the U.S., that child is a U.S. citizen, period.
That's a fundamental assumption for many families planning their lives here, even temporarily.
It really is. But under these potential new rules, the child's citizenship isn't automatic based on birthplace alone. It suddenly depends entirely on the parent's specific temporary legal status at that exact moment, which is, like you said, the opposite of how it's traditionally been understood.
So for those H-1B workers, maybe hoping for a green card eventually, this adds another layer of complexity.
A huge layer. Suddenly, proving their own lawful status at the specific time their child was born becomes critical, not just for the child getting an SSN, but potentially for the parent's own future immigration applications, like family-based petitions down the road.
It turns having a baby into a potential immigration filing challenge.
In a way, yes. You need meticulous records, not just of the birth, but of your own visa status, entry records, everything right around that time.
Let's bring this closer to home for a significant part of our audience, the Indian diaspora, NRIs. Many are here on H-1B, L-1, F-1 visas. If their U.S.-born kids are no longer automatically citizens, what are the consequences?
They're quite far-reaching. That automatic U.S. citizenship provides a lot of certainty, ease of travel, future access to U.S. education and jobs, simpler tax situations usually. If that's gone, the family suddenly faces a much more complicated reality.
How so?
Well, think about taxes, for instance. It can create really significant dual taxation issues. If the child isn't a U.S. citizen, but the parents are still residing and working in the U.S. temporarily, managing taxes between India and the U.S. becomes much more complex, much earlier than they might have expected. They likely need expert advice on international tax law almost immediately. It changes the whole financial equation of working and raising a family here, even for a few years.
So the advice for people in this situation is pretty crucial right now.
Absolutely critical. For Indian students on F1 visas, talking to their campus international student office now is essential. Understand how this might affect dependents, future plans, and for professionals on H-1Bs, L-1s, closely watch how this develops the court cases, any official implementation announcements from agencies like SSA. Before making big decisions about travel, having children here, relocation, they need to factor in this potential legal and financial risk. Strategic planning just got a lot more complex.
Okay, so let's try to synthesize this. Where do things stand right now?
Well, the key thing is, until those court injunctions are lifted and the order is officially fully enforced, the traditional birthright citizenship interpretation is still the law of the land. A U.S. birth certificate should still be sufficient proof. However, and this is a big however, because agencies like the SSA and the State Department are actively updating their systems and preparing for this change, What people can expect immediately is more scrutiny.
Even before the rule is final.
It seems likely. They're moving towards needing dual verification, checking both the birth location and getting documentation about the parent's status. Even while the legal challenges are ongoing, they're building the capacity for it.
So the bottom line, the core takeaway for everyone listening is the administrative burden is shifting. It's moving away from just proving where you were born towards proving your parents' legal status when you were born.
That's the fundamental change. And it dramatically alters the landscape for immigrant families, anyone planning a future in the U.S., even temporarily.
Okay, so here's a final thought for you, our listeners, to mull over. Beyond the immediate paperwork, how does this push towards needing advanced proof of parental status change the long-term strategic thinking for everyone on temporary visa students, workers who might be considering starting or growing their family in the United States? And what might this administrative shift signal about the future relationship between agency rules and established constitutional principles? Something to consider. All the best. And we will meet again with another important subject in the next meeting.